Good morning, Mr. Kimball.
How you doing?
Pretty good. So I've never met you before. I don't know who you are. All I know is that your lawyer is asking me to, I'm assuming, set him a bond, right? You know, you're wanted from somewhere. I don't know for what. I don't know why. I don't know if I'm going to set you bond. I got to get to know you in the short time that I have you here to see, are you a danger to my community? If we give you a bond, are you going to go back? I have no idea. So let's get to know. Amy?
Judge, so he's wanted from Guadalupe County, New Mexico, aggravated battery against a household member with a deadly weapon. As the court knows, he's also being held under 351st for credit and debit card abuse.
No, I had no idea. Say it.
And I believe they also just filed a motion to revoke his probation on the fraud use.
He's on probation too.
Yes, and they're motioning to revoke as well. He also has 2 bond forfeitures that I'm seeing, and then he has quite a bit of history with burglaries and.
My gosh. Whoa. So since 2007, possession of marijuana, possession of a controlled substance, evading arrest, possession of a controlled substance, felon in possession of a weapon, attempted evading arrest or detention, tampering or fabricating evidence, evading arrest and previous conviction, burglary of a building, possession of a controlled substance, burglary of a motor vehicle, evading arrest, credit card abuse, burglary of a motor vehicle, evading credit card abuse, possession with intent to deliver. And 1, 2, 3, 4 more burglary of a motor vehicle, stereo tag D, possession of a dangerous drug. You're on probation for a fraud. You pick up a new credit card abuse, and you want me to set you a bond?
I understand. Can I please tell you something? If you don't mind me speaking.
Don't talk about the case.
I'm not talking about no case.
Okay.
I was in here, being held on the case for the family violence in New Mexico, right? And they just got called ATW twice. They did not release me. I was not released. They sent me back to my cell, and since they didn't release me, they ended up putting a credit card abuse on me. Now I don't know, where that falls in or whatever. They just put it on me.
So if I can give you a brief synopsis of the timeline, Judge.
Sure.
So January 15th, he waived extradition for his New Mexico case, which is why we have a fugitive. He also had a Dallas County hold at the same time, which means the Dallas.
Here's another.
That's true, but Dallas County had 10 days to pick him up. So they did not pick him up in those 10 days. So let's say January.
Well, I know that. I get it.
Let's just say, okay, so they didn't release the whole, they should have released the whole 25th. They didn't. What they did is instead, 3 days later.
Talking the Dallas County hold.
Dallas County hold.
Okay.
So what should have happened is that on the 25th, they released the Dallas County hold, which at that moment, there was no locals or anything pending, and they should have started the timeline for New Mexico to come pick him up. But instead, Dallas did not release the hold until I believe the 29th, because conveniently, on the 28th, the DA's office filed 2B charges on a credit card abuse from a case that they had had since November. So it just,
December. I see here, December 22nd, 2024.
I'm sorry, from December, you're right. So it just seemed like the timeline expired. I believe Mr. Kimball's just really upset because if it should have worked like it should have worked, then, why did they release the hold in time? Why did the DA's office file it? It just seems like they're sort of dragging it along. I understand that he does not have a bond on his felony cases, and they did file the MRP. He has an attorney there who is going to be requesting to set a bond there. What Mr. Kimball is asking is a bond here, even though, and I said, he's going to be making the bond there in felony. So let's say his bonds get set in felony and his bond gets set here. He wants to bond out and go to New Mexico, address that case, and then he said he'll be back and forth. He's already got the MRP and the felony credit abuse case here, but he wants to be able to fight them in the free world, and he is willing to go to New Mexico, turn himself in. I've been in contact with his mother, and I guess just because of that lapse in timeline, it's kind of like why we're here, because, in part, if you have anything else to add, I think he just feels kind of screwed by the system on this. Is there anything else, Mr. Kimball, that I missed?
Now, did she send the video to your phone? Oh, all right.
In 2023 alone, Mr. Kimball, you have 1, 2, 3, 4, 5, 6. In one of the misdemeanor cases, you have presumably a bond at 5,010, which tells me that you've taken off on that case as well.
I
You're
never
on
ran
probation. You had a hold out of Dallas for, what did he have a hold out of Dallas for?
violation.
Out of Dallas.
You're hopscotching with the states with the criminality,
No,
man.
I
I
got
can't.
on. Look, I had all the cases together, and they gave me probation in Houston and Dallas. See, that's what you don't know. They dismissed a bunch of them cases has been dismissed, and I've been to trial twice. A bunch of them cases has been expunged on their record, like that you're saying. You know what I'm saying? But they gave me probation in Dallas and Houston. Dallas supposed to transfer my probation to Houston. They did not transfer my probation to Houston. That's how I get a violation in Dallas. I never violated by kissing any new case. The only time I caught a case is when for the New Mexico, say something happened in a family violence 2020, 2024. I never even been to New Mexico. The girl wrote a statement on me saying that I violated whatever. I understand. I know I don't supposed to tell you nothing, but I got videos. She's saying everything that she said is a lie. I don't even supposed to be having a case for new. I wasn't even supposed to come to jail for that case. She has the videos in her phone. She can show you. She's showing her ID, everything, making a whole statement saying that everything that she said to me in New Mexico is a lie, bro. I'm just dry getting hold for this case.
We really,
I understand it.
it doesn't matter.
Yes, sir. I understand it.
It seems to me
Yes, sir.
you get out, you pick up a new case. You were out, you just picked up a new credit card abuse 2 weeks ago. December 22nd, I mean, maybe 3 weeks ago, you just picked up another case. You're on probation in Houston. You're on probation in Dallas.
Yes, sir.
You got an open case in New Mexico.
Yes, sir.
I can't possibly give you a bond, Mr. Kimball. You know, I think that I need to protect my community. And if I give you a bond, I'm scared that something else is going to happen. I don't want you to pick up a 6th or 7th case, you know?
I ain't pick up a case. I came to jail for a case a year ago for New Mexico. I was already
Yes.
on probation.
Picked up
No, they just put a
credit card
case on me while I was in
Nah.
custody. I didn't never get caught for anything. They just put a case on me while I've been in custody right now. This time, waiting on New Mexico and Dallas to come get me. They just put this case on me. They just put this on me.
I want to make sure that there are no more new cases get on you anymore. I'm not going to give you a bond because, Mr. Kimball, you scare me. You know, you do.
I never had an aggravated case. I never had an aggravated case in my life. You see my record. I never had an aggravated case.
I don't see, the only thing I see
I'm
is
saying
Harris.
everything you're saying. I never had an aggravated case out of Harris County, Dallas, anywhere in Texas, ever. Ever.
I believe you, but it's just way too much baggage, dude. Way too much.
But I'm saying you can't just set a bond on a case. And when I go to court, you know what I'm saying? I talk to my other judge. She give me a bond on them cases or whatever, where I can go handle everything that I need to handle so I can get out and be with my kids. You know what I'm saying? Because if I don't, so say if they do set the bond when I go to court, because he's going to give me a court date in like a week or two. I'm going to go to court. They're going to set a bond for me. So they set a bond. Now I got to come back to your courtroom again for you to say, oh, well, I'm not going to give you a bond or whatever. They got 14 days to come get me. Well, actually, I really supposed to already been gone to either Dallas or New Mexico because they called me ATW twice and they said they was not going to come get me. And we called to New Mexico. New Mexico said they didn't have any knowledge of me even being in jail on their warrant.
Is New Mexico, have they stated that they're going to come get him?
Our indication at this time is that they want him, Judge.
Okay. They're going to come get you. You know, the problem is that 14 days is told because you've not made bond on those cases upstairs. Once you do make bond at that point, that will get the 14 days for New Mexico to come get you. But Mr. Kimball, you've got a ton of priors. You're on probation in two different counties. You got to, regardless, it's too much baggage. I'm not going to give you a bond. You scare me, dude. That's it. Really. You know, sometimes the bill comes due. Now is that time. It's not going to happen anymore. Okay. Thanks.
I had an opportunity. I'm here on Mr. Caleb Jones, judge. Took a look at the bond violation report here.
I haven't even seen it. All I know is that we have another bond violation.
Well, I've had a chance to discuss it and help break it down, make it as digestible as possible, Judge. Essentially, we have some minor GPS violations, a 20-minute exit during curfew about 10 o'clock. and 2 late arrivals, 10:06. And 1 positive BAC.
Right here, the breaking point. Judge Fleischer's patience is dead and buried. After countless bond violations and empty promises, he's done playing nice. No more warnings. No more mercy. Just pure, unfiltered justice about to drop like a hammer. So here's the question for you. If someone kept spitting on the court's trust, would you still show mercy, or would you slam them straight into a cell and make the lesson permanent? Drop your take below, because this courtroom tension is seconds away from detonation.
Come up, Mr. Jones.
Multiple violations. They're on the report that was sent
I looked at
for the first, second, and third.
Yes, Judge. And those reports being referenced there were follow-up lows that showed a declining level on those, unless I'm mistaken.
They go down and then they go up again.
It doesn't matter. It's no tolerance. We've been through this over and over and over. At what point do you get it, Mr. Jones? This is, how many bond violations do we have here now?
I believe this will be the third.
No.
Last time, I believe, Judge. This was at 7502.
Because I was generous with the 2 portion, but it's not just 2, Ben. We've had probably 5 or 6 bond violations. All I know is that you are testing positive. You're in violation of your curfew again. What am I supposed to do? Just continue to let you go?
No, I understand that, Your Honor, but I don't know what I can say about the breathalyzer, sir, because I don't drink. I don't drink at all. I don't know why that the thing was doing that. I had to go back to the Smart Start place the next day, and because they have those little tubes that stick out of it.
I
But
don't,
I don't know. I mean, if you look at the test, you can see that I haven't failed any of my other breathalyzers, and even some of the breathalyzers will say like 1 minute it's failed, and the next minute it's like lower and then higher, and I don't know. But all I
have a
know.
confirmation of alcohol, Felicia.
From the portable device records, yes, they were provided to everybody in the email.
I've had an opportunity to look at those. Just to clarify, in regards to that, there are other instances where we do have BAC readings, Judge, and there are follow-up blows that
They're
show.
not confirmed as alcohol consumption.
And they will say, not confirmed. But we have some that are confirmed. He's blowing on or he's not in.
There was not a follow-up test on this positive, Judge.
No, I'm revoking your bond, Mr. Jones. It can't continue. No, goes with you.
I don't know what I can tell you, Your Honor. I'm not drinking or doing anything. Like,
I have evidence that shows me otherwise.
why can't
And it's over, and it's over, and it's over, and it's over.
Can't we
This
put
is a
me on like
fifth
the-
violation that we have, Mr. Jones.
Why can't we put me on like the ankle monitor drug thing or something like that so I can prove to you that I'm not?
We had that.
I
We
never
took
had
it
that
off.
No, I was never on that, Your Honor. I was.
Judge, if the court would consider
No.
additional conditions, Judge.
I have done everything in my power not to put him into custody. I have let him go over and over and over every time. And I'm done with it. I'm done with it. Something is going in your body that's causing it to test positive for alcohol. He goes with you. That's it. I told you last time, it's no tolerance. You're blowing your GPS, the curfew anyways. Goes with you.
Judge, I may follow up on instead of move on from Mr. Jones. And also, speaking with Mr. Nayland on the case, again, I'm covering for him. My understanding was we were hoping to have a trial setting for this particular
Let's
case.
set it for trial now. It's just way too much drama for me. I'm done with it. I'm ready to put this thing to bed, and that's it. So I'll give you a trial date today. I'm setting the bond at, it's 7502 now. It's gonna go more than that, 12,503.
Thank you, Your Honor.
So
Sorry.
Judge, March 11th for a trial date?
What's the soonest you want, Ben?
Or the 18th?
Give me one moment. I do have his calendar here, so I can at least see if there's any meeting conflicts. Judge, if we could do the 18th, that'd be great.
Anything you want, Ben, I'm happy to give it to you. Really. Let's thing done. You know, once and yeah, I'm with you. Okay, Ben.
Thank you.
Yes, sir.
Hi.
I'm coaching for Miss Delandry Burnett. She's here,
Okay.
and we may need to look at bond conditions. And I know she has a pending felony. The clerk's wet. I can't really pull the conditions up.
So we've got a ton of baggage here, and I don't understand how she has a discharging a firearm in an assault from October 29th. She picks up an aggravated assault in November, and then I guess a week later picks up a criminal mischief. So we have 4 open cases. Is that right?
Yes, Judge.
And we've never addressed any of the bonds.
She's been in custody for,
I don't know. Tell me. Let's.
she's been in,
You know.
when did you marry? Okay. So she was in custody for, right, from October until January, Your Honor.
Did you just make bond on the felony, I guess? Is that what happened? Yeah.
Right.
All right. So a surety bond was posted on the ag assault on 1/9. So let's talk about the complaining witnesses in all these cases. Who are they in relation to the aggravated assault? Any?
So in relation to the aggravated assault, we have not been able to make contact with complaining witness Johnson. But we have been able to make contact with the complaining witness Romero Perez, who was the employee at the business where the incident occurred.
Is this regarding the criminal mischief?
This is regarding the assault.
Okay. What happened in the assault, please?
So, she visited an office that day, and then the defendant began threatening the complaining witness's children, and then supposedly, and the office is the apartment leasing office.
Okay.
And then she went up to the child and then threatened the child and said, look at the exact language. Tell your mom that I'm still here, and pointed a weapon.
At the child.
Yes,
Judge.
a large kitchen knife.
That's a knife. Okay.
Yeah.
So the assault is out of the same transaction as the ag assault then?
Yes, he kicked the first complaining witness in the genitals, causing the employee from
Okay, now the criminal mischief, where's that from?
the criminal mischief
Or-
is from a different complaining witness. He was at his home upon arrival. Officers made contact with him, and he advised that he was at his residence and wanting to watch their children, and or the defendant arrived at his residence wanting to watch their children. He did not initially agree. The defendant then became hostile and caused a disturbance. The defendant then drove her vehicle into the complaining witness's gate, damaging it, and subsequently reversed and sped away. Estimated cost her.
Now this next case takes a dark and shocking twist. A woman accused of threatening a child with a knife. The kind of charge that sends chills through the courtroom. But watch closely. Judge Fleischer steps in with controlled fury and sharp precision. He's firm, unshaken, yet surprisingly reflective when he uncovers one of the strangest bond conditions yet. A library card and a parenting class. You ever heard anything like that before? Because in this courtroom, even justice comes with unexpected turns. And Judge Fleischer makes sure every one of them hits hard.
There's $500.
And Your Honor, that they do have children together, and I believe the rip call, he doesn't want to move forward with the case.
Something very interesting. I don't know if you read this, but, okay, ma'am, I'm going to find that there's probable cause on all your cases, and I'm ordering you as a condition of your bond not to be in possession of any weapons and not to have any contact with the complaining witnesses in these cases. Do you understand? Did the felony court put a monitor on her or anything like that? This is very interesting. Let me read this to you. As part of the conditions on the felony court, it says, defendant must obtain a library card and read to her children.
Oh.
/ must attend a parenting class. That's really interesting. I've never seen that.
It's 228.
The 330. I don't know, but it says
That's a visiting judge. That's a visiting judge.
interesting, right? Did you know about this condition? Okay.
Your Honor, one of the
I'm not
CWs,
gonna impose that, but.
she does have children with, I believe, the complaining witness on the criminal mischief, which is about the gate. And so I don't, just to help them co-parent, I don't know if we could just have no.
But I don't know if he wants to have contact with her. You know, before I allow you to have contact with this gentleman, I would like to know if he even wants to have contact with you. What if he doesn't want to? He may be scared of you. I don't know.
The witness did say that he asked her to drop charges
Yes.
on the case.
Okay, so I'm wording you as a condition of your bond not to have any threatening or harassing contact with, is it Andre, right?
I'm sorry, yes, that's
Okay, do you understand? What is threatening or harassing doesn't matter what you think, it's what he perceives. From point like this, that's could be threatening or harassing contact, so just be careful. You're lucky to be out with these 4 open cases. If I find that you're a danger to my public, you violate any of these conditions, I'm telling you now, I'm going to make your bond extremely high. You know, you're probably not going to have someone to pony up $15,000 worth of bond for you, so be very careful when you're out there. If you have a butting head relationship with this person, just be very careful. You understand? Now, we've given you a lawyer. It's your responsibility to stay in touch with Mr. Elick. If he tells me he can't get a hold of you, likewise, I'll issue a warrant for your arrest. All right? Okay? Just be careful, man. Self-control. Okay. All right, Mr. Elick. I just need you to sign these conditions, and then you're good to go. All right. Thanks.
So is that pre-trial bond condition?
Yeah, with Felicia. Yeah. No, no alcohol, no drugs as well, man. All right? Okay. Thanks, guys.
Judge, can we go over those one more time? My apologies. I got these.
So no alcohol, no drugs, no weapons, no threatening or harassing contact with the gentleman named Andre, and then with the assault and that one, no contact whatsoever. And no going back to that leasing office as well. Okay. Sir, you were charged with evading arrest or detention. On that case, you're facing up to a year in jail and or a $4,000 fine. You're also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That kicks it up to a Class A, so you're also facing a year and or a $4,000 fine on those cases as well. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge. On January 31st, 2025, the officer observed the defendant's vehicle run a red signal light at the 3400 block of Live Oak Street in Harris County, Texas. The officer further observed the vehicle completely failed to stop at a red signal light and activated his emergency equipment and conducted a traffic stop. The officer made contact with the defendant, who was observed to be behind the driver's seat of the vehicle, and the defendant stated that he does not have his identification card with him. And the defendant gave a fictitious name of Fisher Leroy, with date of birth January 1st, 2006. The officer ran the name through NCIC and found a GPS picture that does not remotely resemble the defendant. The defendant was asked if he was given the correct information, and the officer walked back to his patrol vehicle to double check, and the officer then observed the defendant exit the vehicle and sprint away despite giving him orders to stop. The officer ran after the defendant and observed the defendant get into another vehicle, the passenger side. The other vehicle drove away, and the officer gave the last direction of travel over the radio, but was not able to locate the vehicle. The officer walked back to the defendant's vehicle, secured it, and conducted an inventory check, finding a debit card inside with the name Kendrick Davis. The officer ran the name through NCIC and found a hit with a date of birth of 2/10/2003 with multiple Class C warrants, and ran a driver's license check with the defendant's picture and with date of birth. The GPS picture matched the defendant, and he was able to positively ID. And that's it, Your Honor.
So I'm going to find that there's probable cause to go forward on both of your cases. The reason I'm bringing you out now is because there's no bond that's set on your cases, and we have to set you a bond. One of the things that I use to determine on what to set a bond is how dangerous you are, because I've never met you before. I don't know you, and all I know is that you've got a birthday in 5 days. So he's on bond for an aggravated robbery now, right?
Yes, Judge. It's my understanding, I think it was a 2B, it looks like. I don't believe bond conditions and everything were put in place until a few days ago.
Okay. So the charging instrument was filed November 13th of 2024. I think that you may well be right. In that case, it says here, a Kendrick Richard Davis hereinafter saw the defendant heretofore on or about August 12th, 2024, did then and there unlawfully while in the course of committing a theft of property owned by yada, 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 with intent to obtain and maintain control. intentionally and knowingly caused bodily injury to the complaining witness by using and exhibiting a deadly weapon, namely a firearm. Complainant McSweeney advised that defendant Davis proceeded to pull a pistol from his waistband and pistol whip him with it multiple times on his head and face area, causing multiple cuts and bruises to his head and face area. As he proceeded to fall down on the ground, he continued to strike him in the head and face area with a closed fist and then stomp on his face with his foot. Complainant McSweeney stated that he was in fear for his life and felt severe head pain as a result of the assault. I see that he has also picked up an evading arrest in a motor vehicle
Yes,
the
Judge.
day after our two cases. How? Oh, I guess that's how they caught up to him, right?
That's how
They
they
must
caught
have.
him, they found him, and that's when they arrested him on that, and then he got picked up on, I believe.
Okay, so what happened in that case? Is he like driving 100 miles an hour? Is he just?
Yes, Judge, it says that the officer observed the defendant conduct an improper turn and failed to turn into the correct designated lane. They activated their lights and sirens, and the defendant evaded at speeds of 90 to 115 miles per hour for 3.5 miles on the highways and multiple residential and business streets.
Okay. I think that you are an extreme danger to our public, and I'm going to do everything in my power to protect our public. The first thing I'm going to do is I'm going to order you not to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't give a rat.
And now Judge Fleischer steps into one of the toughest, most explosive moments of the day. A young defendant, violent charges, a history of running from the law, and zero signs of change. The defense pleads for mercy, but Judge Fleischer sees straight through it. He sees a threat. Watch how he draws the line in fire between second chances and public safety. This isn't courtroom drama. This is raw, high-voltage justice in real time.
That's behind what is going on in your life. I don't care if there's a burning building. You have to say 50 kittens. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months jail and a $500 fine every time you get into a car and drive. Do you understand?
Yes, sir.
I'm also putting in this affidavit that you're not supposed to be in possession of any weapons as well. If I find that you have a weapon, because I don't know if you're going to get out or not, and because these cases, because of the nature of the aggravated robbery, because of the nature of this one, I'm making his bonds high. I'm going to set them at 20,000 each.
Can I make an argument?
Yes,
Okay.
absolutely.
you,
I
Judge.
don't want to get ahead of myself, please. Yes.
So I was appointed to Mr. Davis this morning. I was able to talk to him a little bit in the holdover. We are requesting PR bonds for both of the cases. He's 22 years old. 21 years old. He's lived in Houston his whole life. He has a lot of family in Houston. His grandparents, mom, daughter, and siblings. Prior to being in custody, he was working at Builders First Source for around a month. Mr. Davis also lives with his grandfather who has cancer. Mr. Davis is his caretaker, is my understanding. Mr. Davis has no savings and was found to be indigent by the court, so we are requesting a PR bond.
I think that he is just a complete danger to our public. I can't possibly give him a PR bond due to the nature of both of the charges that you are facing now. I think that you're a flight risk. You've done everything in your power to evade capture. You've produced false names. So I find by clear and convincing evidence that you're an extreme flight risk. You're a danger to our community. And I'm going to set your bonds each at $20,000. I don't know if you're going to be able to post bonds, but if you do, I'm going to order you under house arrest if you do get out. And I'm going to order you to obtain a GPS monitor on your ankle. Like I said, you will be signing an affidavit with me today promising me you're not to be in possession of any weapons and not to drive any vehicle whatsoever for any reason. If you do, I can have a contempt hearing. Do you understand?
Yes, sir.
So I guess the felonies are set for April 7th. I don't like to set them out too far just in case. If you want to, we can do up to 30 days. It's up to you.
That's perfect.
And then we'll come back. I don't know. We'll see what circumstances have changed, and then we'll go from there and just keep us in the loop. All right. I need you to sign this for me. I need him to sign bond release with Felicia, and then after that, just bring it up. Okay.
Wait, excuse?
Yes, ma'am. And thank you for everything. Mr. Martinez, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You have a bond violation report where it's alleged that you have consumed alcohol when we have ordered you not. No, that if I find I will put you in a. Do you understand?
Yes.
If you are unable to stop, I am giving you the opportunity now. If you are not able to do it, we are going to do it my way. And I promise you, you're not going to like the way that I do it. On this probation, if you do not have a license, you are not allowed to drive. If I find that you drive, you're looking at up to a year in jail. I will issue a warrant for arrest. I'm going to put you in jail and I'm going to have a hearing. And if they prove to me that you violate any of these conditions, you are looking at an entire year in custody. Not only that, but if you are not in this country with permission and you go to jail and you do anything more than 4 to 5, 6 hours, immigration sweeps it on a daily basis. You already know what the administration is doing to undocumented persons. So if you're not here, you best be on living with a halo above your head. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement with me today, you either complete it successfully and you go on your merry way, or you violate this, we issue a warrant and you're looking at up to a year in jail. Do you understand?
Yes, Your Honor.
It is a 1-year jail sentence. I will probate it for 2 years. For you to successfully complete this thing, you must do a TRAS, which is an evaluation to see what conditions you may need. This doesn't say DW education class. I'm assuming it's supposed to be a DW education class,
Yes,
right?
Judge, it's supposed to be.
This needs to be
We'll
refiled.
refile it, Judge.
Are you wanting a victim impact panel?
Yes, Judge, yes, we'll refile it today.
None of that's on here.
I think what happened was Bernadette was here and she had looked at everything. And they said that because there's gonna be whatever the TRS conditions are, I think she actually had Kelsey remove those. Is that right, Bernadette?
report, yes, sir. We can just have it as written, no, but we can put that on the.
Wait, is this a second or something?
Yes.
No, it's not a second. He has a pending one out of Tarrant County. That was in 2019. He was placed.
That's an open DWI right
I
now.
mean,